Second thought. Hoping we give you second thoughts today.
After practicing law for 28 years, I think Mr. Scott is one of the finest trial attorneys that I've ever met, and I'm honored that he's stood by me and represented me throughout these proceedings. 90 days ago, the jury came back and found me guilty on 7 of the felonies. I just wanted to point out to the court that the district attorney originally charged me with 15 felonies, but 8 of them were dismissed prior to the second trial. During that 90 days, I've been incarcerated in the county jail, and I've spoken to quite a few people who are similarly incarcerated, and it reminded me of something that George Orwell said a long time ago, and that is that within every important issue, there are always matters which are never discussed. And one of those matters that has not been discussed here today is the fact that the county jail in which I've been incarcerated is designed to hold 800 inmates, and it currently houses over 1,300. The state prison system, which appears where they're going to be sending me, is designed to handle 100,000 prisoners, and it currently has a population of excess of 153,000. So sending me into the penal system at this point, an overcrowded, overburdened system in which even the healthcare system is under a federal court receiver at the point because it's so abysmal, as opposed to granting probation where I can get out, start picking up the pieces of my life, get to work, find employment in this very difficult economy, but try to work towards resolving whatever restitution orders the court imposes, I think would be much better than putting me into a steel cage for a couple of years and not providing any form of restitution at all. I would much rather find some kind of work and get to resolving the restitution, being under the supervision of a probation officer, strictly complying with all terms of probation as outlined in Mr. Scott's brief. So I would ask the court to reconsider its decision on the probation. I've heard the statements today from Mr. Phillips and Anita. I could go on for quite some time, responses, but needless to say, I have strong disagreements with much of what they said, much of what they represented to the court. I don't believe if they were looked at closely, that much of it would hold water, especially Mrs. Koch or Mrs. Kohler. I think it was very clear in the trial that she looted all of the money that was from me to her. Mr. Luigian presented these tape recordings of our conversations. Those occurred right after I was incarcerated. My wife and I were greatly upset and shocked. We didn't anticipate the jury coming back so quickly. We didn't anticipate that the jury would come back with the verdicts that they did. And so I apologize on behalf of my wife and I that anything that was said is just, we're extremely upset and never have been through anything like this in our lives. So I would just like the court to know that I do apologize. I do recognize that I've made serious errors in judgment. I've made serious mistakes. I would like the opportunity to try to pick up the pieces of my life as quickly as possible. And I also would like to thank all of my friends and my family and my neighbors who've come out here today to lend support, most of them my wife and I. And I just humbly request that the court grant probation so that I can work toward resolving the restitution. Thank you, Your Honor. Thank you.
Now, this case is one that begs for state prison. This is a case that's not only not unusual, it is an aggravated case. This is unusual in the sense that we have someone who has no criminal record who exhibits the sort of aggravated nature of his crimes as we have here. The first thing I'd like the court to consider is the vulnerability of these particular victims. We had relatives of his.
That Courtney was someone that we loved and we trusted, and we had a family bond going back more than 50 years.
We trusted him, and we had an attorney-client relationship. We have Frank Cox, 77 years old, post-polio syndrome. He was essentially partially senile. He was completely dependent on his caretaker at the time of these crimes. We had Betty Moran, who was 93 years old. She was legally blind. She was completely dependent on her caretaker. And we have a caretaker who was not well-educated or sophisticated and was in a position to have to rely on the defendant's advice on how to proceed, and did so. We also have Rex Phillips, who says now he's near 80 years old. At the time of the crimes, he was 76 years old. He does have a bit of a problem dealing with reality in some cases when things don't go his way. He unwittingly allowed the defendant to remain his attorney and allowed the attorney to, in this case, take his $125,000 in homestead money, and that's what was the basis for the theft. So what we have here are very, very vulnerable victims. But we also have a crime that was carried out with the planning, sophistication, and professionalism. In the first case, Cox Moran, the defendant agreed to do the elder's legal work for free. Then when the $410,000 was recovered for the elders, the defendant almost immediately created a forged contingency fee agreement to take 50% and make it look like it was legitimate. He also forged an email from the elder's caretaker to give the contingency fee agreement extra authenticity. All of this was good enough, by the way, to fool the state bar. Fool the state bar. Fool the state bar.
Fool the state bar. Fool the state bar. Fool the state bar. Fool the state bar. Fool the state bar.
Into closing an investigation with regard to Mr. Courtney's taking of 50% of that money. And by all rights, the way he performed this particular crime, he should have gotten away with it. And by all rights, the way he performed this particular crime, he should have gotten away with it.
By all rights, the way he performed this particular crime, he should have gotten away with it. Should have gotten away with it. Should have gotten away with it. Should have gotten away with it.
If it wasn't for some very good investigators and some luck, he would have gotten away with it. Rex Phillips' case, the defendant forged emails reportedly from Mr. Phillips ordering that the homestead money was sent to a, what I call a kidnapped corporation under the defendant's control. And then the defendant lied to the sheriff as part of the investigation by saying he did not know where the money went after he sent it to this corporation. Then he created a convoluted story about Mr. Phillips lending the defendant the money when he testified at trial, and contradicted his earlier lie to the sheriff. What the defendant did is he used the weaknesses in the authenticity of printed emails, not commonly known, and the weaknesses in the Nevada corporation laws that allow someone to take up a suspended corporation and control it without revealing his personal identity as a method for concealing the forged or the embezzled money. And based on the sophistication of what he did in this case, again, he should have gotten away with it. This sophistication is such that we can say that this is not a crime of the unusual case. This is a crime of calculation, of taking from only vulnerable victims. By the way, the court has a number of statements in the probation report from people who are friends of the defendant indicating what a great guy he is. They are all irrelevant. And the reason why is because he does not steal from his friends. He steals from vulnerable victims who have no believability, and he can make up documents to make it look like he took it legitimately. We also have the fact that taking this money was a great monetary value. It's $204,500 in the Cox Moran case and $125,000 in the Phillips case. And that's a lot of money just to anyone, but it was extremely high amount of money to these folks because, as into the two Cox Moran.
My father was forced to die with the belief and knowledge that he was a burden on his daughter.
I'm William Wagner. For On Second Thought, hoping we give you second thoughts today.